Hi, good morning, good afternoon. Welcome to Beyond Blood, the importance of estate planning for people surrounded by friends and chosen family. My name is Sarah Kurth. I am founder of Life, Death, and Paperwork, where our goal is to normalize estate and end-of-life planning conversations, especially for those surrounded by friends, chosen families, and unmarried partners. Our agenda for today, I have a few disclaimers and a few thoughts to consider as we begin. Then I want to help you understand your situation as somebody surrounded by friends and chosen family. Then I'll walk you through a few very basic legal concepts. Then I'll show you what it looks like if you don't do any estate planning and why you probably won't like it. Then I'll show you what it looks like if you do make an estate plan. Then, to help you take action, I have a few next steps. Before we begin, I have to give the standard legal disclaimer. This presentation is for general education purposes only. It is not intended and should not be considered legal advice. Laws and rules vary significantly based on location, and what is appropriate for you varies significantly based on your circumstances and your goals. Contact an attorney or a medical or financial professional for advice specific to your situation. Considering the eventuality of your death and estate planning can be emotional topics. It can unearth lots of emotions and memories. So a few thoughts to consider and a few questions to consider as we begin. Consider these questions and journal about them if you're so inclined. First of all, why did you take this workshop? What has gotten you thinking about estate planning in the first place? Next, have you made any end-of-life or estate plans for yourself? Where are you in this process? Next, what have your experiences been of others' estate planning or lack thereof? I've found that a lot of people who come to me looking for more information about estate planning do so after somebody close to them has died without doing any planning. The resulting chaos has made it clear to them that they do not want to leave that kind of mess behind for their people. Finally, what words or concepts come up with you as you think about end-of-life or estate planning? Understanding your situation as a person surrounded by friends and chosen family. If you die without a will, intestate is the fancy legal term for dying without a will, state law will determine who will manage your estate and who will get your stuff. The laws vary a bit by state, but are always based on some version of figuring out either your legally married spouse or your nearest blood relative. How well you knew them, how much you liked them, or how much you agreed with them doesn't matter. Critically, friends, chosen family, and partners you are not married to do not figure into that equation. The default rules of what happens if you don't do the paperwork aren't what most people would expect and aren't what most people would want. I don't know many people who are surrounded by chosen family who would prefer that their estate go to a second cousin twice removed or a great uncle, not the people close to them. But if you don't do any paperwork and if you don't do any estate planning, that situation might just happen. A few very basic legal concepts before we begin. I do not plan on giving you a Law School 101 primer here, but understanding a few basic legal concepts will help you understand the scenarios that we're going to run through in just a moment a little bit better. Estate planning can get very complicated very fast. I intentionally kept this presentation very high level and straightforward. I'll use plain English, but I'll occasionally mention the legal terms just so you hear them and know what to expect, and don't freak out if you hear them in the wild. In an ideal world, the people who love you the most and are the most involved in your life will make choices for you and get your stuff, but this is not the case. End of life and after a death, you are dealing with two institutions that are very old-fashioned and very red tapey, courts and medicine. Courts and hospitals want cut and dried relationships of blood or marriage, or they want paperwork. They do not want to have to quantify friendships or relationships. One very basic legal concept that is vital in estate planning is determining who will be involved. When dealing with medical, legal, or other official questions, we need to consider who can act, what can they do, and according to what. What rule, what document is allowing that person to take that action? Another concept that is important about estate planning is understanding the difference between you and your stuff. Who can make decisions for you as a person may or may not be the same person who can make decisions about your stuff. Your person includes medical choices while you are alive and what happens to your body after a death. For example, if your organs are donated or if you're buried or cremated. Your stuff is your stuff while you are alive. Your bank accounts, your clothes, your car, and everything else you own. After you die, your stuff becomes your estate. And note that while estate might conjure up visions of mansions and jewels, estate is just the fancy legal term for your stuff after you die. Everyone will have an estate. I've found the best way to convince people to do some estate planning is to help them understand what will happen if they don't do any planning. The specific rules vary by state here, but if you don't do any paperwork, chances are in your state it will look something like this. If you don't do any paperwork and you are alive and with capacity, so you're just a person walking around in the world who can make decisions about your body and your health care, you can. Who is in charge of your money and your stuff? Again, you are. If you are alive but incapacitated, the example that is always used in law school is you are hit by a bus and you're in a coma. Who is in charge of making decisions about your medical care? Your spouse or your next of kin? And it is vital here to understand that next of kin is your spouse if you are married, or your nearest blood relative if you are not married. Friends, chosen families, and partners you are not married to are not considered next of kin. If you are incapacitated, who is in charge of your money and your stuff? No one is. After you die, who makes decisions about what will happen to your body? Again, it is your spouse or your next of kin. Who is in charge of managing and who will get your money and your stuff and your estate? Once again, it is your spouse or your next of kin. And again, I want to note that next of kin is your spouse or your nearest blood relative. Friends, chosen families, and partners you are not married to will not get your money or your stuff if you don't do any paperwork. So, what does all of this look like if you do the paperwork, if you do some estate planning? If you are alive and with capacity, this will look very much the same. Who is in charge of making decisions about your body and your medical care? You are. Who is in charge of your money and your stuff? Again, you are. There is an option here of setting up a power of attorney if you want somebody else to be able to sign on your bank account or to help you manage your business affairs while you are alive with capacity, but that's optional. If you are alive but incapacitated, so again, this is the scenario where you've been hit by a bus and you're in a coma, who is in charge of making decisions about your body and your medical care? It is your healthcare agent, or sometimes called your healthcare proxy. And this person is appointed via either an advanced care directive or a living will. The term varies by state. If you are alive but incapacitated, who is in charge of your money and your stuff? You can appoint a power of attorney via a durable power of attorney form to let somebody else sign on your accounts, pay your bills, and make other decisions on your behalf. If you've done the planning, after you die, what happens to your body depends on the state where you live. In most states, the healthcare agent or the healthcare proxy that you've appointed via either an advanced care directive or a living will be able to make decisions about your body disposition. But in some states, your healthcare agent appointment ends at death and does not include the ability to make decisions about what happens to your body after death. In those states, you will need to appoint a separate person to make decisions about your body disposition. Specifically, how to do this and what form is required to make that appointment varies by state. After you die, who is in charge of your money and your stuff and your estate? Your executor is the person who will manage your estate and distribute it. You appoint your executor in your will. Your will is also the document where you will list who you want to get what stuff. There is an option here in some instances to name beneficiaries directly on accounts such as investment accounts and retirement accounts. If you've named a beneficiary on an account, those funds will go directly to the beneficiary after you die without having to go through probate and the court system. Naming beneficiaries on accounts is a great way to get some of your assets to the people you want to get them without having to go through the court system. So that's a lot. And hopefully I have convinced you that some estate planning and some paperwork is necessary. So what exactly does that mean? Here are a few places to start. For more information on any of these items, talk to an attorney, an accountant, or a financial planner, or access reputable DIY resources. One way to avoid estate complications is for assets to never become part of your estate. As I just mentioned, many of your assets can be transferred to others at your death automatically and without the involvement of the probate court. Adding a named beneficiary to retirement or investment accounts, or adding a payable upon death beneficiary to bank accounts will make transferring those assets easier after a death, since those assets will not have to go through probate. Next, complete a living will or an advanced care directive. The specific names these forms use vary by state, and in some states it's 2 separate forms, and in some states it's 1 form with 2 parts. A living will documents what medical choices you do and do not want made if you are ever incapacitated and cannot speak for yourself. An appointment of healthcare agent or an appointment of healthcare proxy is a document where you will appoint the person you want to make decisions on your behalf if you cannot make those decisions for yourself. In some states, like where I am in California, an advanced care directive is a single document that contains both a living will and an appointment of healthcare agent within a single document. An advanced care directive or a living will is a vital document if you want somebody that you are not married to or that you are not related to be able to make medical decisions on your behalf if you cannot make them for yourself. A good place to start here is with your health insurance provider. Most have living will or advanced care directive forms that you can use. Next, write a will. Your will names your executor, the person who will be in charge of managing your stuff and your estate after you die. And your will also lists who you want to get your stuff. Since your friends and chosen family aren't automatically entitled to anything in your estate, a will ensures that your stuff will be managed and distributed to them. Next, consider a durable power of attorney if you want a friend or a chosen family member to be able to deal with your financial accounts, pay your bills, or deal with other affairs if you are alive but incapacitated. Make sure your power of attorney is durable if you want it to remain valid in cases of incapacitation. In most states, the healthcare agent or healthcare proxy that we just talked about above in a living will or an advanced care directive, that person's rights include deciding what will happen to your body after you die. For example, if your organs are donated or if you're going to be buried or cremated. However, in some states, body disposition is not included in your healthcare agent's rights. In those states, a separate release or waiver is required to ensure that your preferred person is making those choices. Just to make this extra confusing, what that form is called varies by location. Finally, document your stuff. After you die, all of your accounts will have to be closed and all of your stuff will have to be located and distributed. That is a major undertaking and will have to be done by your people at a very difficult and emotional time. Documenting important information and accounts will make that process just a little bit easier. Document information like where your accounts are, where your important documents are, important digital accounts and passwords, for example, email and online banking usernames and passwords. Want to document your stuff, but you're not sure where to start? I've attached a list of items to document to get you started below. If you want even more guidance on what you should document, I have a full checklist available for sale on my website. A link for that is also below. So, I just threw a lot of information at you. If you remember nothing else from everything that I just talked about, remember that if you do not do any paperwork and don't do any planning, your friends and your chosen family will not have a say in your medical care, will not be able to manage your estate, and will not get anything from your estate. So if you're surrounded by friends and chosen family, it is vital that you do some planning to ensure that those people that you are not related to by blood or marriage will still have a say in your medical care and will have a say in your estate after you die. The document that I always recommend people start with is a living will or an advanced care directive. Completing this document will ensure that the person you want to be making medical decisions on your behalf is able to do so. And it will document your healthcare preferences to help guide that person and your medical team if it's ever necessary. So start there, and after that, just take it one document and one step at a time. Thank you.